Hello, and welcome to the New York State Youth Justice Institute's Forum on COVID-19 and Youth, Beyond 2020, the Next Normal. My name is Gisela Lopez, and I am the Executive Director of the YJI. We have a diverse audience here today. Many of you come from local and state governments in New York and all over the country, as well as universities, nonprofits, and research centers from near and far. If you joined us yesterday for our discussion about education, welcome back. Yesterday, we asked you to tell us in one word what you were taking away from the forum. Right about now, you should see your responses. Much like you, I too was filled with renewed sense of compassion, inspired by the panelist discussions and by our keynote. And today, we're absolutely honored to have a stellar roster of experts to lead our discussions over the next few hours. My many thanks to the panelists, to the moderators, and to our fantastic keynote speakers, Dr. Isaiah Pickens, New York State Chief Judge Janet DiFiore, and Professor Gary Young for sharing their brainpower, their experience, and their passion with us. My thanks also to the entire YJI team, and especially to Avery Irons and Alicia Gagnon. Their dedication and thoughtfulness in organizing this event already makes it a success. I am also grateful to Dana Peterson, Michelle Ellis, Vince Dilio, Tony Galveo, and Kristen Conklin for all their help and thought partnership. Last, but in no way least, many thanks to our partners at the New York State Division of Criminal Justice Services, the New York State Office of Children and Family Services, SUNY Albany, and to the New York State Juvenile Justice Advisory Group for all their unwavering support. Exactly 1 year ago, as New York had become the American epicenter of the pandemic, in a virtual forum, much like this one, the YJI brought together researchers, policymakers, community representatives, practitioners, funders, and advocates to answer a fundamental question: are the kids all right? And further, we asked, are all kids all right? As we centered our discussions on the pandemic's disparate impacts on historically marginalized populations, including youth of color, youth with behavioral health needs, LGBTQIA+ youth, youth with disabilities, and immigrant youth. We would like to share with you a few insights from that national cross-stakeholder conversation.
So the pandemic is not just a public health crisis, it's a racial and economic one. The people most impacted by this are youth, our elderly, is because of the racial, health, and economic disparities that we have in this country.
There's not an equal distribution of this. So again, an encouragement to look individually at each family, look individually at each child, to really think about what the impact is. We don't want broad strokes because that does not really help us be prescriptive in terms of what families need.
We can't be like reactionary. We can't just talk about only the risk and not about prevention, like not about what foundation is needed to like help make a child whole.
High-speed internet access or having equipment is a basic right. You're realizing that folks can't communicate. They can't be part of this new civil rights movement because they simply don't have the materials they need, materials that should really be as basic as food and water.
Reform is never applied toward communities uniformly, and you can't expect the same impact on communities that have long histories of violence and oppression from the state.
I created a 3-person evaluation team to review the youth that were currently in detention at the time of the shutdown, so to speak, using these revised admission criteria to determine which youth may be released to alternatives to detention. And this resulted in a 95% of my detained population being released. And I want to point something out. To this day, not a single one of them have disrupted or reoffended. And that's extremely important because it begs the question, should I have allowed them in the first place?
families are experiencing loss, and I think they haven't had time to grieve. And I think that that's going to be an issue going forward. There was a lot of people who lost their lives during this pandemic, and families are going to have to find a way to grieve, this process, because they weren't able to say goodbye to their loved ones.
One of the things we know is that when people belong, first of all, their capacity to resist trauma is greater. That is, the effect of an event is less likely to be traumatizing if you are in a space where you belong. And part of belonging is just that, is to be really seen. There's a South African word called sabalonu, and it's translated, I see you. It's also translated, the God in me sees the God in you. But for many young people, especially young people of color, they don't feel seen, so they don't have that network.
So we can be resilient, but let's not mistake at all that we are not hurt by the things that we go through. And I think sometimes resilience can be used in a way to mismanage the trauma and the punishment that these children are going through.
Part of what we need to be talking about in this conversation is that reforms can only go so far. We have to be ready for them. Our heart has to be ready for them.
This pandemic has shown us that changing our reliance on juvenile detention is possible.
I hope you were able to enjoy some of the highlights of last year's forum, and I want to point out that this video was produced by then YJI scholar Samaria Alpern, one of our students here at the YJI. In New York now, a year later, we dare to begin seeing an end to this pandemic, marked by increased access to the vaccine and by revisions to social isolation policies. We also dare to believe that the age-old calls for racial justice that echoed loudly in 2020 may have begun to resonate, or at least they did so in one courtroom in Minneapolis. All in all, we have reached what feels very much like a transitional, perhaps even transformative moment. In moments like this, the ancient Romans looked to the god Janus, who had one head looking forwards and one head looking backwards, for guidance. Janus's great power was to see both the past and the future, to see inward and outward, all at the same time. At moments of change, he took lessons from what he saw before and planned for tomorrow. As we emerge from our pandemic lives, what do we see in the future? Do we see a next normal for our schools teaching children in new ways? Or do we see regression and exclusion from lost education? Do we see a better normal for our criminal legal system, which has found new ways to deliver justice? Or do we see old inequities replicating themselves? Do we see our youth whole, healthy in body and in mind, at peace, civically engaged, ready and eager to learn? Or do we see our children, our teens, our young adults contending with wounds exacerbated by the pandemic and caused by racism, ableism, and other isms that are endemic in our health, education, and justice systems? To prepare for this year's forum, we convened 3 groups of experts to help us prioritize what youth really need in this transitional moment, in the immediate future, and permanently. One focused on education, another group on courts, and one on trauma and healing. We asked them, what questions should we be asking as we move beyond the pandemic? Who can help us look forward while looking backward? We're grateful to everyone who served on those panels. In a way, they were our Januses. Today's event, which you're about to see, is certainly made better by their insights and hard work. The rest of the work is really up to you, our audience. Your job today is to listen and watch, ask questions, and to learn from what others show you. We're scholars, educators, community members, government officials, youth, and family representatives. We each have our own experiences of this pandemic, and we all have thoughts about what can or should come next. But this event will work best if, like Janus, you look not only within yourself, but also outwards to what others are showing you. If you reflect on what's behind us and help us craft a path forward. Perhaps a place to start is to try and imagine the world as it is experienced right now by our young people. To those of us with kiddos at home, we may have seen firsthand the toll the pandemic has taken on our teens' mental health, or the inevitable learning loss that came with the shift to online learning, especially for our kids with disabilities. But we don't need to reach for personal examples. Our young people's trauma, their viewpoint is painfully public. A year and a week ago, at age 17, Darnella Fraser showed us a video of what she saw during this pandemic. Walking to the corner store with her little cousin, they witnessed the murder of George Floyd, a Black man, by Derek Chauvin, a white police officer. And when Darnella shared that video, she showed us all something that we might not have seen otherwise, or worse, that we might have chosen not to see. As we look back to look forward, let us look within ourselves, but let us also always try to remember what others, what young people like Darnella are showing us. Let's get started. At this point, I'd like to invite our incredible YJI fellow, Alicia Gagnon, to share the virtual stage with me and to introduce us to today's keynote speaker, New York State Chief Judge Janet DiFiore. I think Alicia's grandmother, Marge, is in the virtual crowd today, so allow me to make Alicia blush as I tell Marge and all of you in the audience how proud we at the YJI are of Alicia. Alicia, keep being awesome and take it away. Thanks.
Thank you. Hello, everyone. My name is Alicia Gagnon, and I'm a research fellow here at the Youth Justice Institute. I would like to echo Dr. Lopez's thanks for coming today and hope you'll join me in extending a warm welcome to our keynote speaker, Chief Judge Janet DiFiore. We are all very much looking forward to sharing her recorded presentation with you all, and we know that you are looking forward to hearing her remarks. But before starting, we would like to introduce her and share with you some of her many accomplishments. Chief Judge DiFiore was a reform-minded DA who worked collaboratively with stakeholders to address the needs of underserved communities, such as poverty, gang violence, domestic violence, child abuse, and the use of DNA to prove the innocence of wrongly convicted individuals. From her earliest days as a prosecutor, Chief Judge DiFiore has been a big believer in cross-agency collaboration and in working with local communities and faith leaders to address the root causes of criminal behavior. We asked Chief Judge DiFiore what had inspired her to pursue a career in law, specifically in law enforcement. She said, "When I was 12, a cousin of mine was arrested for a very serious crime. He was tried and convicted. I attended, along with his heartbroken mother, every minute of the court proceedings, and as I observed the solemn gravity of the judge on the bench, the adversarial roles of the prosecutor and defense counsel, and above all, had the opportunity to witness firsthand how our criminal justice system worked to hold people appropriately accountable for their misconduct. That experience turned out to be one of the formative experiences of my life. I loved my cousin, but I also understood that there had to be consequences for his actions. And when the trial was over, I knew two things in my head and in my heart, that justice had been done and that I wanted to be a prosecutor and a part of that system of accountability. Chief Judge DiFiore has been deeply involved in public service for most of her career, beginning as an assistant district attorney in the Westchester County District Attorney's Office in 1981, appointed as chief of the office's Narcotics Bureau in 1994, and elected to the Westchester County Court in 1998, where she presided over criminal and civil matters in the Family Court, Surrogates Court, and Supreme Court. Here she served until 2002, when she was elected a justice of the New York State Supreme Court, and then just 1 year later was appointed to serve as the district's supervising judge for criminal courts. In 2006, Chief Judge DiFiore was elected as the district attorney of Westchester County. In this position, she was able to push for substantial improvements within the court system. She improved services for family violence victims, adopted innovative education and crime prevention programs, and established the Child Fatality Review Team, which brought together multidisciplinary groups of professionals to investigate and determine necessary actions to prevent future deaths. To date, Chief Judge DiFiore has served on several commissions, including as former co-chair of the New York State Justice Task Force, which has successfully proposed reforms to address the systemic causes of wrongful convictions. In January 2016, Chief Judge DiFiore was unanimously confirmed by the New York State Senate as Chief Judge of the State of New York after being nominated by Governor Cuomo. Upon being sworn into office, she announced the Excellence Initiative, which focused on a detailed evaluation of current court processes with particular attention to reducing delays and backlogs within the court system. As part of this initiative, Chief Judge DiFiore has introduced reforms to support civil pro bono legal assistance for low-income New Yorkers, implemented the nation's very first opioid treatment and intervention courts, adopted presumptive early alternative dispute resolution in civil and family court matters, and introduced a proposal to amend the state constitution to simplify the structure of New York's trial courts. In response to the COVID-19 pandemic, Chief Judge DiFiore presided over the creation of virtual courts to ensure the continued provision of essential justice services while slowing the spread of the virus by minimizing courthouse traffic and in-person interactions. Within this past year, as with the rest of her career, Chief Judge DiFiore has demonstrated a tireless commitment to maintaining, building, and improving court systems to best serve public interest by administering justice in a fair and efficient manner. Without further ado, we now present Chief Judge DiFiore with her kindly pre-recorded presentation for us today. In just a few moments, we will begin sharing the video.
Thank you, Ms. Gagnon, for your very kind introduction, and good morning, everyone. Welcome to the COVID-19 and Youth Forum Beyond 2020, the Next Normal. Allow me to start this morning by thanking the New York State Youth Justice Institute and Executive Director, Dr. Giza Lopez, YJI Fellow, Alicia Gagnon, and Associate for Technical Assistance, Avery Irons, for inviting me to address you this morning. On behalf of all of us in the Unified Court System, I want you to know how impressed we all are with the work of the Youth Justice Institute, such a unique partnership between the State University at Albany, the Division of Criminal Justice Services, the Office of Children and Family Services, and the New York State Juvenile Justice Advisory Group. The research and technical assistance YJI provides to localities in support of evidence-based youth justice reforms in our state is invaluable to all of us, and YJI certainly deserves our thanks and recognition for its important work and for convening this extraordinary 4-day gathering of leading judges, practitioners, advocates, and experts from across the state and across the nation to follow up on the critical question that was posed exactly 1 year ago today at the first COVID-19 and Youth Forum. Are the kids all right? So now, while we are grateful that the pandemic, by all indications, appears to be subsiding, we know that our young people, especially those from vulnerable populations and underserved communities, have experienced unprecedented disruption and trauma in their lives over the last 15 months. And notwithstanding all of the losses and the harm caused by COVID-19, history does teach us that there is indeed opportunity in every crisis. And so we are grateful to YJI for convening this forum and giving us the opportunity not only to make sure that the kids are all right, but as importantly, to learn from and capitalize on the positive innovations of the last 15 months in order to make sure that our next normal will be a better normal. And to our focus point today, a better normal for court-involved children and families in our state. And as you all come together from so many disciplines and backgrounds to reimagine a more humane, effective, and racially equitable youth justice system, I would ask you to keep two important questions in mind. First, what can our court system do to support your initiatives to reform the broader youth justice system? And then what it is that you can do individually and collectively to support our courts as we work to improve the quality of youth justice services and ensure positive outcomes and equal treatment for young people appearing in our courts. When the pandemic struck New York in March 2020, our court leaders, judges, and our professional staff did a remarkable job of transforming our massive, complex, in-person operating model into a functioning virtual model capable of safely providing court access in the broadest possible range of cases. Our courts remained open and functioning at all times to hear emergency and essential matters, including family offense matters, child abuse and neglect cases, cases involving 16 and 17-year-olds in our Raise the Age youth parts, as well as juvenile delinquency proceedings, which were prioritized and promptly heard in our virtual courts night and day, 7 days a week. Our new virtual court model brought many improvements in court access and services, including the ability to schedule time-certain virtual appearances, allowing families to avoid the frustrating experience of waiting sometimes hours in crowded courthouses to have their cases called, and who now feel like they are receiving individualized attention and that our courts are respectful of their time and effort to promptly resolve their matters. But notwithstanding the positives that we have discovered, we must and we do remain sensitive to the fact that for many low-income families, there is a digital divide in accessing our virtual courts, because they lack what so many of us take for granted: high-speed Wi-Fi, data plans, and basic computer equipment. And of course, we are addressing this urgent challenge on many fronts and working closely with the legal services community and a broad range of stakeholders to ensure meaningful access to our virtual courts. In an important step forward, our Permanent Judicial Commission on Justice for Children rose to the challenge last year by providing online training programs to attorneys representing children and parents, as well as child welfare staff, on how to use virtual technology platforms to ensure full and fair participation for families and children in family court hearings. The Commission also produced a series of free programs for parents, youth, and attorneys on how to navigate our virtual family courts, and we are grateful to the Commission's Chair, Karen Peters, the Commission members, and Executive Director, Kristen Conklin, for their timely help and valuable assistance. And as we continue to move forward, we will seek and maintain appropriate improvements in virtual court access and services, and our court leaders, judges, and staff will continue to be thoughtful and deliberate about that process, And toward that end, we are most interested in any relevant data and research emerging from this forum. And we are deeply interested in receiving your findings and recommendations as they relate to meaningful access and participation of families and children in our virtual courts. In addition to the impact of virtual court proceedings on justice-involved youth and families, I know that your agenda is focused also on the perennial challenge of fostering better outcomes and reducing racial and ethnic disparities for court-involved youth. Before highlighting some of the innovative initiatives that are underway to address those challenges in the New York State courts, I do want to remind everyone of the positive strides our state has made to improve the youth justice system and expand age-appropriate, community-based services and interventions. Last December, we received the final report of Governor Cuomo's Raise the Age Implementation Task Force, which found that the landmark 2017 legislation raising the age of criminal responsibility from 16 to 18 is achieving its intended purpose of diverting young people out of the adult criminal justice system and into our family courts. The task force found that as of June 2020, no one under the age of 18 was being detained along with adults in local jails or state prisons, and that confinement of young people, when necessary, is now taking place in specialized youth-appropriate facilities. Under the leadership of Edwina Mendelson, our Deputy Chief Administrative Judge for Justice Initiatives, and Thomas O'Neill, her senior law clerk, we have used the forward momentum of the Raise the Age movement to support and launch a whole range of collaborative initiatives that are helping us to keep more young people in our communities and expand the provision of age-appropriate services and interventions. In addition to these advances, the pandemic provided us with a glimpse of what a less punitive youth justice system might look like. I know that many of you are carefully studying the pandemic-related changes in youth detention practices that led to dramatic reductions in confinement of young people. Along the continuum of policing to adjudication to incarceration, the pandemic compelled us to pivot away from punitive measures in favor of diversion and community-based options. And judges in our family courts and youth parts across the state conducted status conferences with prosecutors and defense counsel to assess the status of each confined young person in order to determine whether continued incarceration was necessary and was appropriate in each of those cases. And so now we have a golden opportunity to examine the data and learn from our recent experience in order to identify sustainable further reforms and best practices that will enable us to limit unnecessary prosecution and confinement of young people. And this forum presents us with the opportunity to double down on finding solutions to the disturbing racial and ethnic disparities that continue to plague the youth justice system. Because we know that Black and brown youth still account for a much larger share of arrests and probation intakes than their proportion to the general population, and that our detention facilities are largely occupied by young people of color. We also know that despite the dramatic decline in youth involvement with the justice system during the pandemic, youths of color continue to be arrested and detained at much higher rates than white youths. Among the many things this pandemic has done over the last 15 months, it has helped us by casting a spotlight, a harsh spotlight, on longstanding inequities and racial disparities in all corners and across our nation. Recognizing that these deeply troubling disparities permeate all aspects of our society, and that our courts are certainly no exception, last June I asked former Secretary of Homeland Security Jay Johnson to lead an independent, no-holds-barred examination of our court system to help us to identify and eliminate from our institution any and all forms of racism, bias, and disparate treatment. Secretary Johnson issued a comprehensive report which identified many areas of concern for us, and our entire court system is now engaged in fully implementing the Secretary's equal justice recommendations, an initiative marked as a highest institutional priority for us. And our collective efforts to identify and remedy the causes of racial and ethnic disparities among court-involved youth are in total alignment with that priority and with our commitment to maintain public trust and confidence in our ability to ensure equal justice under the law. The reasons for the persistent racial and ethnic disparities in our youth justice system continue to be examined, and they are many and they are complex and complicated. But we do know that the majority of youth who come into contact with the justice system have experienced trauma in their young lives, trauma that often contributes to participation in harmful behaviors. In recognition of these factors, our court system is working to reduce trauma on many fronts, including our Child Welfare Court Improvement Project, a federally funded initiative overseen by the Office of Justice Initiatives and statewide coordinator Trista Bora, designed to promote the safety, permanence, and well-being of abused and neglected children. We are also working to strengthen the quality of legal representation for indigent parents in child welfare matters, so very important to preserving the integrity of families and the well-being of children. And our family court judges and staff working all across the state are compassionate and dedicated to their work, and they are deeply committed to preventing and healing trauma and tackling the causes of racial and ethnic disparities. Fostering a more humane, less punitive youth justice system has been a focus of our judges, and I do highlight our New York City Family Court judges and staff led by our Administrative Judge Jeanette Ruiz. A significant case in point is our Community Resolve Initiative, a restorative justice pilot involving the New York City Department of Probation and several other stakeholders that emphasizes accountability and healing through interventions and services that help young people to understand the harm they have caused, make amends to victims and communities, heal relationships, and prevent recidivism. And of course, the innovative work that is underway to reduce the disproportionate number of girls of color in the juvenile justice system is exceedingly important, work that we are very proud of and we are committed to. In response to studies showing that girls confined in facilities are much more likely than boys to suffer long-term negative consequences, Judge Kathy Davidson, our administrative judge for the 9th Judicial District, created our new GRIP court. GRIP stands for Gender Responsive Initiatives and Partnerships, and the court's focus is to improve justice outcomes for girls of color. The family court judges assigned to the GRIP court work to bring stakeholders together to develop and implement a holistic approach to the specific needs of each girl, with a strong focus on providing each individual with community-based interventions and services that provide the support and stability they need to get back on track and allow them to move forward in safe, healthy, and productive ways. Fantastic work, and kudos to Judge Davidson and the GRIP court team. And finally, I want to draw your attention to the work we're doing with respect to emerging adult justice, the 18 to 25-year-old population that makes up only 10% of the population, but 24% of the arrests in New York and 29% nationally. I am sure that everyone here in attendance today is aware that the research shows that the transition from adolescence to adulthood is a time when the brain is still developing, and it's a time when young adults are more susceptible to risk-taking behaviors and peer pressure. Building on the experience of our pioneering Brooklyn Young Adult Court, a collaboration between the Center for Court Innovation, the Brooklyn DA's Office, Defense Counsel, and social workers, and with the support of our Office for Justice Initiatives, we are working with prosecutors, defense counsel, and community service providers in 3 pilot locations to develop age-effective court approaches for nonviolent emerging adult offenders in the New York County Supreme Court criminal term, in the New Rochelle City Court, and in the Mount Vernon City Court. Again, important work focused on helping young adults build the foundations necessary for healthy, productive futures. I hope that my remarks today and my brief overview of the innovative and hopefully inspiring and ultimately successful reforms that are underway in our courts serve to underscore how deeply committed we are to working collaboratively with all of you, our partners in justice, to reimagine a more humane, a more rehabilitative, and a more community-centered youth justice system for our state. I want to thank YJI for sponsoring this wonderful forum and for convening such an impressive group of experts and advocates around this most timely and urgent agenda. And as you pursue that agenda for reform and as you formulate your recommendations for action, please ask yourselves and report back to us, what can our court system do to support your efforts to reform the broader youth justice system? And what can you do individually and collectively to support our quest to improve the quality of youth justice services, foster positive youth outcomes, and ensure equal justice for young people appearing in our courts regardless of who they are or where they come from in life? Finally, I simply want to thank each and every one of you for your service and for being the strong and committed leaders we need to move forward together beyond the flawed practices of the past and toward a more effective, just, and racially equitable youth justice system across our state. Thank you.
Thanks so much to the Chief Judge for her kind words about the YJI, but primarily for her informative, urgent, and inspiring message. Thanks again, Chief Judge, for that. For those in the audience, when you first registered for the forum, we asked you to tell us what you think justice-involved youth need today. We've compiled all of your answers into a video, and we will share that with you momentarily. We have also prepared an interactive activity for you to reflect one of the questions posed by our Chief Judge. At this point, or at any time between now and the end of today's event, you can follow the link on the chat and tell us what courts can do to support the community initiatives for reform. Once you've done that, you can also tell us in one word what you're taking away from today's forum so we can continue to build that word cloud that we showed you at the beginning of today's event. A reminder that your contributions will be added to that word cloud and that we hope to share that with you as we wrap things up today or later on tomorrow. Before we move on to the panel discussions, as I just mentioned, we will leave you with your answers to the registration question, followed by a very brief break. Now would be a very good time to stretch, grab a snack, take a bio break, and refuel for the panel discussion that will begin momentarily. Thanks again for being with us today.
Thank you for joining us.
Welcome back, everyone. We'll now move on to what I'm sure will be an incredible panel discussion on evaluating and sustaining court-based innovations. Let me begin by introducing each of our panelists, as well as our moderator. It is my pleasure to invite Charles Rice to share this virtual stage with us. Charles is the Hudson Regional Youth Partner at Families Together in New York State. For over 10 years, Charles has dedicated himself to mentoring and working with youth who have been labeled at risk for involvement with the justice system. Through his own lived experience overcoming significant hardship, he has discovered the value of mentorship and support, and now strives to extend the same opportunity to all youth. Welcome, Charles. We're also delighted to have with us Jim Acker, a distinguished teaching professor emeritus at the University at Albany, and my personal mentor. Much of his research and focus in teaching has been on the integration of social science into law, focusing on a range of topics from wrongful convictions to juvenile justice. He has produced a staggering number of research articles, as well as authored or co-authored several books, including Scottsboro and Its Legacy, Wrongful Conviction, Law, Science, and Policy, and 2 Voices on the Legal Rights of America's Youth, the last of which was produced with his daughter. Welcome, Dr. Acker. Next up is Linnea Anderson, the Juvenile Court Administrator for San Juan County in Washington State. In addition to juvenile court services, she manages the operations of the San Juan County Volunteer Guardian Ad Litem Program, the Public Defender Screening Program, and the Courthouse Facilitator Program. She also serves as an officer on the executive board of the Washington Association of Juvenile Court Administrators. She is the co-chair of the association's Strategic Planning and Education Committee, and she serves as a member of the association's Legislative and Finance Committees. Recently, Linnea has been appointed to the Washington State Board for Judicial Administration Court Education Committee and C19 Court Recovery Task Force. Welcome, Linnea. I would also like to welcome to our virtual stage Dr. Melissa Sickmund. Melissa is director of the National Center for Juvenile Justice, the longest running juvenile justice research group in the United States. In her role, Melissa has overseen a wide array of highly informative products, all dedicated to supporting decision-making at national and local levels through qualitative data and descriptive statistics. Some of the work that she's overseen produced by the organization includes the National Juvenile Court Data Archive, the Juvenile Justice Model Data Project, and the National Juvenile Justice Data Analysis Program. She is perhaps best known for the Juvenile Offenders and Victims publication series, which is part of the National Juvenile Justice Data Analysis Program. It is wonderful to have you, Dr. Sickmund. Rounding up our fantastic panel is Deputy Chief Administrative Judge Edwina Mendelson, head of the New York State Unified Court System's Office for Justice Initiatives. She has been a central figure at implementing measures to reduce instances of racial bias and enhance gender equity within the New York State court system in accordance with the findings of the Justice in Courts Initiative and the Judicial Committee on Women in the Courts. Judge Mendelson also directs several juvenile and family justice initiatives, including the Child Welfare Court Improvement Project and the Advisory Council on Child Fatalities. As of this year, she also oversees the Unified Court System's Office of Policy and Planning. Welcome, Judge Mendelson. At this point, I'd like to welcome also the Administrative Judge for the New York 7th Judicial District, State Supreme Court Justice, and our moderator for the day, Judge Craig Doran. He has been member of the New York State Permanent Judicial Commission on Justice for Children, co-chair of the New York State Juvenile Justice Strategic Planning Advisory Committee, and is now, we're proud to say, an executive board member of our own New York State Youth Justice Institute. He's also a member of the Office of Court Administration Raise the Age Task Force. Judge Doran, on top of all of this, also teaches at the University of Rochester and Cuba College. With that, take it away, Judge, and thank you again.
Thank you, Giza. Hello, everybody. It's so great to be with you all. We have an amazing hour and a half ahead of us here. One of the unenviable tasks I have is to try to keep us on track time-wise, so I'll do my best to do that, as Judge Mendelson would say, and I'm going to preempt her on this. I do have a habit of adding editorial comments here and there, which sometimes can go on a little bit long. So please know that I'm doing everything I can to keep things moving here. I want to thank the Youth Justice Institute and to all of you who've chosen to occupy this moment in time with us, albeit virtually. We are together, and we are together at a time when the situation demands that we do more than we've ever done before to meet the challenges. You know, I believe that we are put in places for a reason. And I believe very much that we've all been put together in this space at this time because we are expected to do things that have never been done before, to stretch the envelope, push the envelope a little farther than it's ever been pushed. Three words come to mind for me right now. that helps us meet the moment: inspiration, collaboration, and perseverance. We have inspiration in droves, not just from those of us that are together here sharing this moment, but certainly from our chief judge, who has created a very fertile environment for doing bold, innovative things, for thinking in ways we've never thought before. So we have her inspiration. We have the inspiration of so many of our partners, so many of the people who are part of the immediate court family, but also the broader family of folks that we work with. And that brings me to the second word that is on my mind today, and that's collaboration. We cannot possibly meet the challenges that we must meet without collaborating. We must collaborate with each other in ways we never had before. We must reach out to each other in ways we never had before. And we have to think of those that need us the most now in ways that we never have before. And by collaboration, I don't just mean in the traditional ways, but I mean that those of us that are blessed to have the power, the authority, the privilege to be in places where we make decisions that affect others, we have to be agents of change. We have to do more than just sit in our courtrooms and wait for the cases to come to us. You know, for decades, it was not a natural thing for judges to come out from behind their benches and work with others and collaborate with others. You heard from our chief judge, those days are long behind us now, and Judge Mendelson also has certainly been a champion of collaboration. But I also mean collaboration with the academic world, something that I personally think we can do much more of. There's so much research, so many dedicated, passionate individuals, many of whom are with us today on this call, who've made it their life to continue to try to find ways that we can serve youth and families better. We need to have a regular line, a rapid infusion of that research and the academic and scholarly spaces that we haven't traditionally interacted with on a regular, continuous, and frequent basis. That's why I'm thrilled about my privilege of being part of the board of the Youth Justice Initiative. The final thing I want to mention before we begin the first question is perseverance. There will be moments in this conversation where we will be discouraged, where we will hit obstacles that seem insurmountable. We must overcome those obstacles, and we must not allow ourselves to be discouraged. The moment that we're experiencing right now, brought about by challenges, is a unique moment. I'll dare to say a moment that only comes around maybe once in a generation, maybe once in several generations. In order for us to take advantage of this place that we're in, we have to persevere. We have to be willing to have the uncomfortable conversations. We have to be willing to disagree and to listen to each other and to put aside what sometimes are the traditional roles we hide behind and get out there and be with each other and get the job done. So I'm thrilled about the discussion we're about to have. It's going to be one of those battery chargers for all of us, and I'll do my best to keep us on track. So we are actually a little bit ahead of time, which is a good thing. So hopefully we can maybe we'll bank that time and use it at the end for questions and answers from the panelists. So the first question, and I want to alert our panelists that we do have an order that we'd like folks to take maybe 3 or 4 minutes and respond to the question. This first question will start with a response from Judge Mendelson, followed by Charles, then Jim, then Linnea, and then finally Melissa. So first question to our panel. In the Chief Judge's keynote address, Judge DiFiore challenged all of us, in particular youth justice stakeholders, to be bold and innovative and to find ways to support each other, perhaps untraditional ways that we haven't thought about in the past. So to the panelists, from your vantage point, what are some concrete ways for the stakeholders to respond to that charge? And feel free to mention any current or promising examples that you're aware of where you sit or stand. So, Judge Mendelson, nice to see you virtually. The floor is yours.
Thank you so much, Judge, and thank you for that wonderful introduction to this wonderful panel that we have for you. Knowing our data regarding the system-involved young people is what I find to be foundational and necessary before we can start being as bold and innovative and responsive as our Chief Judge has asked us to be. Every stakeholder in our juvenile justice system should have a handle on the data as it regards race, ethnicity, and other disparities that are experienced by our young people in our systems. And we need to know our data about arrests, prosecution, confinement, and other outcomes and dispositions within our regions, compare ourselves to the rest of whatever our state is, as well as the rest of the country. And Chief Judge DiFiore mentioned the good news in terms of our data, because right now we are experiencing the smallest system touch on young people that we've had in a very, very long time. And looking at our data, we know that over the course of the last 20 years or so, we have had a 70% reduction in our juvenile justice as well as child welfare activity at all of those data points that we look at. And this lasted through our COVID season of horror for many of us and great distress for many of the children and families we serve. A smaller system is the good news, but there's still very, very bad news. And the data shows us this bad news. And that as we are significantly shrinking our system, we are increasing the overrepresentation of young people of color in our juvenile justice system, which should deeply disturb us all. The good news in New York State that I want to highlight, because I start by talking about data allowing us to be bold and brave as we move forward in this space, is that our state system, our Division of Criminal Justice Services, which is partnered with our Youth Justice Institute in this unique and remarkable way, they have just launched a new data program that is user-friendly and separates out young people from the adults and allows us to take a really deep look at the young people who we are serving in our system. And that allows us to look and be troubled by the things that trouble us, like we have a few long-staying young people in confinement that we're going to be able to focus on and thinking of strategies to respond. When I participated in this program last year, and I'm grateful that you asked me back again to participate a year later, tomorrow will be the anniversary of my presentation to you all in a panel last year. I talked about the pandemic being a point of crisis where we as a court system, and Chief Judge DiFiore mentioned this in her remarks as well, as a court system, we focused on looking at the young people who are in confinement and a shared responsibility where the prosecutors, defense attorneys, community advocates, and judges all did case reviews to ensure that only children who needed to be confined were in confinement. That's a concept that we need to hold on to, and that sense of urgency that we had during the public health crisis, we need to keep in terms of our equal justice crisis that is ongoing, in terms of the overrepresentation of youth of color in our systems. So the idea of boldness being necessary, it's scary to be bold and innovative when we are seeing an uptick in violent crimes, which I think will be raised at some point as we are talking about, but that doesn't excuse us from our obligation to continue to look at promising practices that are community-based for that. And I'll stop in a moment after saying the current promising examples that we have were mentioned by Chief Judge DiFiore. Our GRIP part, our girls specialty part that we have in Westchester County, along with our emerging adult justice parts that we have in New York City, Westchester County, and plan to expand where we're looking at the 18 to 25-year-old population and utilizing that same science that brought us Raise the Age to our emerging adults. Thank you.
Thank you, Judge Mendelson. Charles, you're up next. Judge Mendelson, thank you for focusing on the data, because that leads to our honesty. And we have to be honest. We have to face the facts, unpleasant as they may be. And also, thanks for focusing on keeping the urgency. I can tell everybody with the utmost confidence throughout this pandemic. There have been days when I've talked with Judge Mendelson multiple times, and the issue of constantly reevaluating youth that are being detained and constantly reacting to some of the things that we're reading about in the media across our state, some of these alarming things. We need to be in constant communication and not be afraid to continue the conversations, even when there are some, quite frankly, frightening things happening around us. So Charles, I met you virtually today. I can't wait to meet you in person. The floor is yours.
Definitely. Thank you so much for having me. As it relates to this question, one of the things I think we need to just ask ourselves is, are we looking at a community or are we looking within this community? I think one of the things, even prior to the pandemic, prior to everything that's going on with COVID, that began to happen as a society is we began to take a hands-off approach to a very hands-on problem. We were, calling into telehealth prior to having this implementation of telehealth for like a burn or a bullet wound that our community is having. And we're saying, okay, great, we're going to put a Band-Aid on this. Or we're going to say, okay, I can't touch that right now because it's a little bit out of my realm of influence or far away from my scope. And I think we need to really look back at what got us into this work in the first place. A lot of us came from these places and a lot of us come from these same communities. And a lot of us remember getting like our hands dirty and putting our boots in the mud and saying, okay, we need to be the reason that things start to change. And I think we get to a place where we become comfortable and almost complacent with where we are as a society. And we're like, oh, okay, well, it's not that bad. Or maybe it's not the community I live in anymore. Or my children don't have to deal with that anymore. And I think that's a huge issue that we need to address, is saying, okay, what does it look like for me to step, as you mentioned earlier, from behind my desk? What does it look like for me to step out of my office? What does it look like for me to get back into these communities? Because one of the things that I learned working in finance and mortgages is that people do business with people they know, like, and trust. And if your community's never seen you, yet you're telling them that you're going to bat for them, how much trust can they have in you? How much can they trust that you're going to actually be here for their community if you've never actually stepped foot in their community? And so I think that's one of the biggest things that we need to look at, is saying, okay, I need to step into this community that I'm supposed to be over. I need to step in this community I'm supposed to be a part of and I'm supposed to be going to bat for, so I can see what it is that these people are saying. I need to be a part of this so that I'm not just sitting up here looking down on them saying, oh, I feel bad. Because for me, that's understanding the difference between cultural competence and cultural humility. Cultural competence says that you can acknowledge that there is a problem, right? If you see a 3-year-old fall into a pool, competence says, oh man, that baby's gonna drown. Humility says, I need to do whatever I can to jump into this pool and do what I need to save this young person. And that's what we need to learn to do as a society.
Charles, I'm going to steal that phrase, cultural humility. That truly is describes so much of what we need to do. And we need to get out into the community. And one of the things we're grappling with in the court system, you heard Judge Mendelson and the Chief Justice talk about, talk about the need to enhance the trust that the community has in us. This loosely woven together concept of justice doesn't work if those who are seeking justice don't trust us. And we need to be humble, and we need to be in all environments having these conversations. Charles, great words. Thank you so much. Next up is Jim, and he's given me permission to call him Jim. I feel a little bit awkward doing that because I'm a proud graduate of SUNY Albany, and I never would have called you Jim when I was in one of your classes, so I feel honored. But Jim, we're happy to have you. What do you have to share on that first question?
Well, I'm honored to be here, and I'll keep calling you Judge out of respect for your competence and your experience and who you are. I am really pleased to be a part of this discussion. I listened with interest to the Chief Judge's remarks and the remarks of Judge Mendelson and yourself, Judge Doran. And by golly, it is refreshing, I must say, to think about the role of judges in a different spirit. I think traditionally, most people conceive of the judicial role, and it's a very important one, clearly, of presiding over cases, adjudicating suspected and accused individuals who may have offended. But there is a much more ambitious role potentially available to judges and courts generally. And the Chief Judge asked, what can courts do to interact more effectively with those outside of the judicial community? And conversely, what can those of us do who are not immersed in the court system to help the judicial system? And Judge Doran, to follow up on your suggestion, which you've presented here very nicely, I think there is imminent potential for partnership, effective partnership between the court systems and academia. I've spent a long time in an academic context, and I can tell you, if there had been any outreach from a judge or a court system to my dean or myself or some of my students, boy, we would have jumped at the chance to become involved. There's such prestige and authority associated with the judicial role. It would be too much to pass up. Now, obviously, you all in the judicial role are very busy doing other things, so there is no reason that a dean, a faculty member, a student shouldn't initiate that outreach and hope to find a receptive ear on the other end within a courthouse. I think there are good models for this. In the university system, there are plenty of programs in criminal justice, social welfare, and beyond that would be naturals for these interactions. In law schools, there are lots of subdivisions, innocence projects, immigration initiatives, indigent representation. Law schools will be a wonderful home to support a youth outreach. And what could be accomplished here? My golly, there'd be potential for research, policy reforms. My guess is that during the pandemic, those in a judicial role had to reallocate their time to some considerable degree from adjudicating because cases weren't coming in to doing other things. And maybe there's something to learn here about time budgeting so that those who are in the courts can think about doing more in getting out in front in terms of doing efforts of prevention, community outreach involving others, and then at the rear end of the system too, with respect to alternatives to confinement, restorative justice, and that sort of thing. So all I'm saying is these are good times to be thinking about collaboration and partnerships between academia, the courts, and of course, many, many others in the community. There's so much potential here.
So Jim, the invitation is here. It's living, breathing. We're engaged in these collaborations. I've been a judge for 20 plus years, and I've never seen the environment more favorable to those untraditional collaborations. Our worlds don't necessarily naturally neatly fit together. There have been historic obstacles to those worlds getting together, but I think the challenges facing us now have overcome those obstacles. And you heard it from the top, our chief judge, and I can tell you numerous ways that Judge Mendelson's office every day supports these initiatives across the district, where we are partnering with academic institutions to literally come into our courthouses and work with us to better serve the people we're serving in frankly a way that's more informed and informed based on the science. So the sky's the limit, the invitation's there, great times ahead. So we'll keep persevering. Yeah, I think it's still morning where you are, so good morning, and we're so happy that you're with us all the way from Washington State. And I look forward to meeting you in person one day as well. I love the Northwest. It's a beautiful part of the country, and we're happy to have you with us.
Oh, thank you so much, Judge, and the New York Institute. I'm so honored to be here with each one of you today in this amazing panel. Judge Mendelson, I think you really talked to the point of data. I think that is so important. This convergence of judicial and academia is so important. And I also think that, Charles, part of that you brought up around cultural humility and being in the pool, if you will. I think we can do better, not just counting those metrics or those touches with members of the public and court users, but also receiving some data back from court users and understanding how court users are experiencing our system. I think that is really valuable information for us to move forward to making bold innovations within our judicial system. And the last thing I want to just point out is how exciting. Here I am all the way on the other side of the country, and being bold is also part of what our judicial branch has taken up and is really spending a lot of time on, and how exciting it is to know that your system is doing the same. Thank you so much.
Thank you. You know, one of the greatest synergies that I've experienced during this pandemic has been the degree to which the states are working with one another. Judge Mendelson and I are on the Chief Judge's Commission to Reimagine the Future of the Courts. And almost every one of our meetings has involved some input from our colleagues across the country. We've heard from chief judges in other states. We've heard from court administrators in other states. We really do have so much to learn from each other. Kind of embarrassed that we haven't done it as vigorously in the past as we're doing it now, but the important thing is that we're together now, and next year, God willing, we'll be together in person. So thank you, Linnea. Last but not least, on the first question, Melissa is next up. Hi, Melissa.
Well, thank you so much. I feel like I don't need to say anything because I agree with everything that everyone has said. I think I am so appreciative of Judge Mendelson's comment about data, because that's usually where I come in. I've worked at the National Center for Juvenile Justice since 1986. We are the research division of the National Council of Juvenile and Family Court Judges. So I've spent my career trying to get judges to want data, to care about data, to realize the importance of data. Oh yeah, and research. And so we often encourage courts all over the country to work with their local universities, those land grant universities that have an obligation to pay back to the communities where they are. I think that's, can be a wonderful partnership. You have to do it carefully, but the idea of having more and better data, and I think touching a little bit to what Charles was talking about, that connection to community. And Linnea, you mentioned the, getting the input of youth and families. So while much of the data that we kind of play around with is administrative data, having survey data and focus group data, talking to people directly who are impacted by the system, and just asking them what, did they feel respected? What do they need? What do they want? How, are you doing the things you think you're doing if you ask them the question? Sometimes we think we're doing things and the recipients of our efforts see it very, very differently. So that, giving youth a strong voice. The idea of, the question, I guess, that Judge Defuary had about, disparities and what we should be doing. I think one of the things that I'm coming to believe in my old age is that we should maybe focus a little bit less on looking at the disparities in kind of the harsh things, the negative outcomes that we do to kids, and maybe focus a little bit more on, are we providing equal access to the things that work better for those youth? To be very specific, not every program is perfect for every kid. To do a better job of matching to kids' needs, and sort of the question also said, are there current and promising examples to look at? And I'll just give a shout out to some work going on here in Pittsburgh, the Black Girls Equity Alliance, which was started by Kathy Elliott and Gwen's Girls, which is a private service provider, but has membership of university folks, nonprofits like myself, probation. There's a whole slew of other service providers that are involved, looking at data from the community, from police, from the schools, from the courts, to see what is it going on? Why do we have this overrepresentation of Black girls, particularly in the court system here? Things like that then turn into a really creative conversation for what could the solutions be to keep kids just out of the system. Diversion without strings attached. Don't bring them in. The ultimate diversion is when a person sees some disruptive behavior or even is the victim of a crime. If it's not too serious, to not pick up the phone and call police, but who else could I call? So the system, I think, can do a much better job, especially if there's money savings involved, to reinvest those funds in the communities. Kids shouldn't be punished because the community they're from doesn't have services or resources to support the kid. That's not the child's fault. So we need to do a better job making sure that all communities have what they need to support families and to let everyone succeed.
Melissa, I want to highlight something you said there, which I thought was wonderful. Diversion without strings attached. It reminds me that we do positive things. We talk about positive things, but we need to do more than that. We talk about diversion. We use that phrase in its traditional sense, but usually we're talking about it in the context of what we've always done. We develop new programs, but we stick to the old principles. We need to throw the old principles out and start from scratch. And in many instances I can think of, we have built into these diversion programs some of the traditional separateness that has always divided us. We don't make them, I'm going to use Charles's phrase, we don't make these programs culturally humble. We certainly don't make them culturally competent, but I think we have a higher bar now to be culturally humble. And if we think that way, and if we throw out some of the traditional ways we've always done these things, you're on a diversion program, you break the rules, there's accountability. Sometimes we set people up for failure before they even begin, particularly with young people and families. Your comments are spot on, Melissa. Thank you. So next question, and we're we're on time, knock on wood. The next question, Charles, you are first up, and this is directly relevant to the research issue. So you can dream up the 1 or 2 research questions that you would like our academic partners to answer. What would those questions be, or what questions would you ask in order to best determine which adaptations during the pandemic we should keep and carry on into the future, or which ones should we abandon? So what questions would you want to have asked by our research professionals if you could have your wish? And Charles, throw in, who should we be asking the questions to? I think that would also be an important part of the response. Charles,
Definitely. I think we can actually ask a very general question as it relates to this. And I think that general question will be, what did we do about it? Right. So we have this conversation about all these things that, we want to implement, or all these changes that need to be made and all these things. But it's okay. Great. We've had these conversations, but what did we actually do about it? Great. We've brought these families and these young people to the table. We've heard their voices. Now, what do we actually do about the things that we said we wanted to do with these changes that we've made? Right. And so, we talked about Judge DiFiore mentioned how, the access to technology with this virtual court is something that, a lot of communities and people are struggling with, but it's okay, great. We understand that there is a problem there. Now, what did we actually do about it? Are we just going to talk about it? I know there's an old saying that a goal without a plan is just a dream. And really what we need to look at is this idea of a conversation without action is just a waste of time. Right? We can talk about things until we're blue in the face, but if we're not actually doing anything about it, we've just wasted a bunch of time that we'll never be able to get back. So we need to ask every researcher, anyone who's trying to figure out, okay, what worked, what didn't work, what do we need to do that's going to be better? We need to ask ourselves, well, what did we actually do about it? Great, we've had these wonderful conversations. What did we actually do? What were the tangible steps that were taken to say, okay, great, this worked, and now we can move forward? And so I think that's one of the biggest questions. I know it's really general, but I think it's a great question to be asking is what do we actually do about it?
I think you're 1,000% correct. We spend too much time. We do need to spend time gathering information about how we're doing, but we neglect the next step. And by the way, I'd love to have you at most of the meetings I have all day long, so you could keep, okay, what are we going to do about it? We've talked about it. What are we going to do about it? Excellent question. Excellent participation. Thanks, Charles. So Melissa, you're next up on this question.
I think I would add on to what Charles said and ask, again, two really basic questions, maybe three. In the changes that we made, who was helped and who was hurt? Because we know that there were things that helped in access to justice, but on the other hand, there may have been other folks, other parts of the system that were hurt. So to go through with each and every change that occurred and apply those two questions to it. Who was helped, who was hurt? And that should help you along the way to figuring out what you want to keep and what not to keep.
Judge, you're muted.
Oops, thank you. Thank you, Judge. I think Judge Mendelson was there, that voice in my ear, as she always is. Thank you. Sorry about that. I wanted to comment on that as being important to our end game. What are we in the business to do? And what do we want to avoid doing? Well, we want to help folks. We want to do everything we can to do that within our roles, and we don't want to hurt anybody. So excellent. Thank you, Melissa.
I would say even, in looking at that, not just in terms of the court's clients, but the various system actors. Recently, the National Juvenile Defender Center released a report from a defender perspective, and it was so different than the information that our organization and the National Center for State Courts and others have been collecting about what judges and courts think. They were all very proud of all the changes that they made, and the defenders are going, no, stop.
Right. We do need to know not just what the consumer is thinking of what we're doing, but probation departments, DSS, DHS, et cetera. We need to hear feedback from all of our collaborators. Excellent point. So next up is Judge Mendelson.
So I have two research questions, but before I do that, I'd like to give my moderator a headache and behave as if I were the moderator and he was a panelist by going off script for a minute. Only because I need to respond, or I feel the need to respond to a few things that we've heard. And I think I want to highlight some interesting information and ways that we can actualize and operationalize some of the things we're talking about. I have before me a report created by the Youth Justice Research Collaborative in New York City, and it's entitled Evaluating the Implementation of Raise the Age in New York City. What's remarkable about this particular collaborative, and it relates directly to both youth justice and racial justice issues, which we're interested in talking about today, is this collaborative came out of the Raise the Age movement in New York State, and they are designed as a collective to center the lives and conditions of those most impacted using participatory action research to join experts who have direct experience of youth prosecution and incarceration with a team of academics and advocates. And I've met with these folks a number of times, and it's a partnership of a variety of organizations in the City University of New York, the Children's Defense Fund. They're issuing reports, they're doing court observations of how Raise the Age is operating on the ground in New York City, and they're meeting with court leaders and others to challenge us with how well we think we're doing in this space. So I thought that is a great example of academia, participatory research, which is not something we're usually doing, and receiving information from the community. And the other thing I want to mention is that just today, earlier, it ended at noon, my participation, so I was cutting it close. But the Permanent Commission on Access to Justice in New York State had its yearly law school consortium meeting and presentation, and the Chief Judge gave opening remarks to that as well. But the topic of discussion that I was participating in had to deal with racial justice in the courts, but it was all of the New York State area law schools gathered together and offering and telling us that we must make sure we include them in our system improvement endeavors and giving us examples as to how we can do that. So in response to the whole idea of how can we embrace the court and community and academia, along with those who are most directly involved, we have a few examples and we have our charge. So now, my two research questions, which is not going to, then I have a doctorate in criminal justice. It's my secret. So call me Dr. Judge during this panel, but I'm excited to be in this space and talking about things like data and impact. So my questions are a little different. My first question, I really am, as a judge and as a court leader that is amazed by how well we're doing in reducing the justice system touch on young people, I'm worried about the violent crime. And I want to know what's behind it. I want to know whether youth are being disproportionately impacted by violent crime. Are they the alleged perpetrators of this uptick in violence? I think we want to research and study and figure out what it is about the violent crime that we're hearing about in New York and around the country, because I don't want this to stop us from doing what is our charge to do, to make the fairest justice system we can. And I think we have to face that thorny issue. And the second research agenda I have for you all is I want to know what the true data is on race when it involves our youth and families. I've looked at some, and I want to know what the data sources are. Are we collecting, we have youth justice data as it relates to race and gender, but I'm seeing a word called other, and I don't know what that means. So are we looking at the young people and their families and guessing and checking a box? Or are we asking? Is it self-report? So my magic wand in the research arena would have us question and challenge our data sources to make sure the quality is the best it can be.
Excellent. Thank you, Judge Mendelson. Dr. Judge Mendelson. Next up on that question is Jim.
All right, well, thank you. Whatever else we might say about this pandemic, it's presented a natural experiment for social scientists to really dig into. When I go to my doctor for my annual physicals, there's always a baseline, and we look and see what's gotten better and hopefully what's not gotten worse year in, year out. And we have a baseline now. We have pre-pandemic measures, I would assume, of youth behavior, including offending, how the courts are working, what we're doing with respect to detention, confinement, how staff are working, and so forth. And then we have the intervention of the pandemic, and now we can measure any changes in both directions that may have occurred. So we can determine what has changed, at least in the short run. And then we get to the thorny question of why have these changes taken place? And of course, the pandemic caused us all to reorient our lives significantly, including young people. They were out of school. They had more idle time. They were probably, many of them, under different forms of supervision than in pre-pandemic days. The police doubtlessly changed their behavior. Court personnel were altered from their normal way of doing business to other ways. So once we determine what changes have occurred, we can start to think about why they've occurred, and then hopefully we can ask and get some insights into many questions involving, do we need detention as we used it in the old days? What about these virtual court appearances? Pre-pandemic, what kind of familial disruption was caused by having to report to court so frequently? During the pandemic, have there been improvements? Has it gone in the wrong direction? So I'm kind of sketching more of a general methodology than specific questions, but there is so much potential here. And the last thing I would say is that in addition to this kind of a pre-post analysis, one might envision what we would call a cross-sectional analysis. I know there are people from outside of New York participating in this forum, but in New York, for example, we have 62 counties, I believe. I think that's right. And there's going to be tremendous variation within counties with respect to changes that have occurred. And maybe we can learn something quite interesting from comparing how counties A, B, and C changed in these areas versus counties C, D, and E in these other areas, and what were the different approaches, and might they have made a difference? So there is so much potential here for engaged social scientists, again, working collaboratively with those in the court system to get some very interesting research underway.
Thank you, Jim. Excellent points. And I really like the idea of studying disparities in geography. Even in the district that I supervise, we have Rochester, which is a very urban community with many of the issues that are driving the conversation today getting in the news. But we also have some of the most rural parts of the state, different types of challenges, but still access challenges. And even in that smaller geographic area, sometimes I don't think we are flexible enough to adapt to the differences. And that type of research would be very helpful and informative in helping us adapt to the disparity. So Linnea, you are last but not least on this question. What are your two favorite research questions that you'd love to have answered?
Great, thank you, Judge. It's actually kind of three, but one is very related. So my first question.
We're ahead of schedule.
Okay, great, perfect, thank you. Is to study safety. Moving to remote courts and remote hearings and services, there's a lot of emphasis and discussion that it's created a safer environment for staff, for people, but I'm curious if that's really true. Have these measures and changes, have they really increased or decreased safety? Are there areas where maybe we don't realize where safety has perhaps decreased? For instance, we had a young person in a remote hearing, and off camera prior to the hearing, we could see that this young person was having a conversation with someone, and it looked like it was getting heated, but everyone was muted. We couldn't see anyone. It wasn't appropriate to call it out and ask. But are these blind spots? Are we asking the question? And I think the same can be asked for trauma-informed practices. As we're making these decisions and setting up our calendars and things, are we really making impacts in having more trauma-informed practices? And then lastly, it's about remote hearings, specifically to access. We've talked a lot about bandwidth and people not having technology and different things like that. So as we are moving and having more remote options, are we really moving the needle to a more accessible and equitable systems? And what can we do about it? To quote Charles, what can we do about it to increase that? My little jurisdiction is very small and rural, so I appreciate you bringing up those points. My county is a county of islands. We are not contiguous to each other or to the United States. So we are a very small island, a small county of many islands. To come to the courthouse involves, for many of our residents, an all-day travel by boat or plane. And so the way we've done about it is we've put our court staff out in the field and in communities, bringing hotspots, bringing tablets and other things to help people get that access. Can we collaborate in more ways? Are there more system partners that we could increase that access? And could that be something that larger jurisdictions can do? Can we just do it because we're small? So those are my questions, and I'm just so grateful that we're having these discussions.
Thank you, Linnea. Those are excellent questions, and where you are from sounds absolutely beautiful, even though it comes with challenges. Just one final, if I can add this, it occurs to me that much of what we are endeavoring to get a handle on is how what we're doing affects the perception of the litigants. and in the instances we're talking about here, the children and their families that are in our system. I would love to find the best research-based way to get from these folks, how did they feel about the process, and did that change? Many of these folks have been before the court pre-pandemic, and many of them have appeared now virtually. I'd be interested in the right way to ask, how did that change in platform affect the trust that the folks have in the system, how they felt about the proceeding, how they felt about the outcome, a lot of those intangibles. What's the best way to get that information? And are we moving the needle, as you said, Linnea, on those big ticket items, which are removing disparities, making the system more equitable, and frankly, making it more trustworthy? Next question. And thanks to everybody for your patience and for sticking with us as we move through these questions as quickly as we can. So for those of us that are around the law, we know that the courts and the law and precedent and the rules that we have to follow, all of those things move very slowly. And we are enjoying right now this moment in time where change is happening rapidly. So this question is designed to elicit from our panelists, what of those pre-pandemic assumptions, those things that we always were critical of, but we never bothered talking about because we knew there was no snowball's chance in you know where that change would ever happen in our lifetime. So now we're in a space where change is happening with light speed. So which of those pre-pandemic assumptions should we reevaluate given the moment that we're in and the fertile environment for change? And as a follow-up, what of the changes that we have made do you think are here to stay, or do you want to be here to stay? And which do you think we should leave in the rearview mirror as we emerge from COVID? And first up for that question is Linnea. You don't get a break, Linnea, you're up again.
Great, and I'm so glad we're talking about this, that whole concept of not a snowball's chance, so we've just accepted things. I hope that we never accept service deserts ever again. I hope that we never, ever accept that people will not have access to necessary services, especially court-ordered services that are going to be tied to major liberty consequences. The work that we have done in our court recovery task force, we've worked closely with our healthcare authority. We took advantage of this major tragedy and this crazy crisis that we're all going through, and we said we're going to make the best of it, and we're going to talk about these silver linings. And this is the moment that we asked our healthcare authority, it was their time to shine, to change their licensing requirements for behavioral health services so we could increase telehealth services, especially to communities like mine and other rural communities that have virtually been cut off from services, or the services that have been present have been less than a quality framework or a developmental framework, or have lacked some serious integrity. And so through that, I hope that we continue to move the needle and ensure that we remove the desert. I think before the COVID, we just accepted that there were some areas that were just not going to have resources and were not going to be served. And I think now we're seeing that maybe we can change that. And so I hope that that continues to stay and will never fade. Also in Washington State, I believe our child welfare court advocacy and child welfare court processes are largely going to remain virtual. We're not, these hearings are not two-party hearings. You know, you could have 5 parties and multiple witnesses from all around the state, and having it be more virtual or scheduled also plays into that piece of a trauma-informed practice, and also ensuring a higher degree of access without consequences. Families who have to line up in the courtrooms or the hallways for hours waiting for a 9 o'clock hearing, finally being heard at 3 o'clock in the afternoon, and concerned that they lost their job, the one thing that's going to move them forward. So how can we ensure that that's lasting change? And then last, what will fade I'm just going to take a hopeful stance. And my greatest wish for the state of Washington is that the thing that is going to fade is our acceptance of service deserts, and especially around, the other thing that I hope will start to fade is this concept that trauma-informed or a therapeutic court is an alternative court. I hope that those things are going to start to fade. I think we see that we can do better, we should do better, and hopefully we're going to have the research and our partnerships with academia that will help us advance those things forward. And so punitive punishment systems are going to be a thing of the past. Thank you so much.
Excellent. Thank you. I'll tell you what's occurring to me is what an incredible job the YJI has done putting this panel together. This conversation is remarkable. I wish it could go on for a longer time than we have. Jim, you're next up with that question. What do you think we should carry with us, and what do you think we should leave behind?
Well, I feel like I should begin by acknowledging that I lack experience in this area, so I'm really going to defer to those with greater expertise, but I can make a couple of general observations. First, the kind of preliminary part of the question as posed almost, it more or less assumed that courts are precedent restricted and bound, and by, we're a static institution and so forth. I'm not so sure that whatever static effect precedent has in other areas of the law, it's so dramatic in the area of juvenile justice. The doctrines that govern juvenile justice are rather permissive. Fundamental fairness, best interest of the child. There is oodles of discretion available to those who work in this area of the law. And with respect to changes that may or may not endure for better or worse, this discretion puts a lot of authority in the hands of the local court systems and the communities in which they operate to make determinations of what in fact will perpetuate and should perpetuate and what should not. It goes without saying that the juvenile justice system is a part of a larger justice system, which is a part of a larger society. And some of these larger trends in society that we've seen with respect to the adverse consequences of the pandemic, but beyond that, in terms of the eye-opening incidents, again, with respect to racial justice and racial inequities, concerns about policing, to the extent that these grander themes in broad society are going to play out in different directions, I think there will be implications for how juvenile justice is administered. And I believe whatever else we see in the short term, we're likely, I hope I'm wrong, but we're likely to see an uptick in juvenile offending, at least in the short run, simply because business was not as usual during the pandemic, and there were different systems of social control. And now kids are going back to school. There's going to be more time on their hands, less supervision. But even if there is a blip up in offending, I would hope that we have the patience to understand that this is likely to be momentary, and that the longer term trends we've seen toward less detention, less juvenile offending, hopefully will persist. So again, I'm going to have to defer to the experts in the area about what changes should and should not endure. I do think it would be interesting to get focus groups comprised of community leaders, court officials, educators, to talk to one another and to work through issues of this nature, and then kind of compare what the focus groups come up with in terms of good changes, bad changes, what we should keep, what we should not. But let me stop with that.
Excellent, Jim. You keep apologizing for not having insight to this answer, and then you knock it out of the park with your right on the money responses. So thank you. Melissa, you're next up.
So I think in an odd way, the one thing that we, as a change that is here to stay, is that we know that this big, huge bureaucracy that has always moved very slowly can turn on a dime if it has to. And so we should, as Linnea was saying, we should never accept this. Oh no, we can't do it. That's just BS. You know, you have to really want to, but you know, that's the truth now, and nobody can hide from that. I think things like the time certain scheduling, God, I hope that courts that have had cattle calls, everyone show up at 9 a.m. and maybe we get to your case at 5 p.m. I hope that we don't go back to that. And all it took was Zoom going, no, you have to tell me a time for your meeting. Like, you know, this was not hard. I think one of the interesting things is sort of this court professionals becoming much more aware of trauma and stress and their own need for self-care and wellness considerations. Our organization was doing these short little Monday morning moment wellness things that were probably more popular than some of our conferences weekly during the pandemic for judges and anybody else who kind of found the link. Because, you know, certainly being a judge can be very stressful, but certainly during a pandemic, all the change. But I think that made the court professionals a little bit more aware of, oh, that's what's everybody's, you know, everybody is feeling the stress of being in court, of being involved in this system and not knowing what the outcomes are going to be. And that could be, you know, incarceration or, you know, removal of children and those types of things. I think that may, in some instances, have led to just an increased kindness and you know, willingness to accept some little mistakes, especially during hearings. When we have judges that have made Zoom mistakes and been on mute, and you know, that they too are human, and that maybe helps the trust factor. Oh my God, that cat video. No, I am not a cat, judge. There's a filter and I don't know what to do. And honestly, National Center for State Courts has a cool little, they call them tiny chats, where they talk to the judge during that hearing about how, you know, just sort of the access to justice and the humanness that put everybody, you know, like you are just real people too. When you're in court, maybe up higher than everyone else in a black robe, you are untouchable. But then there's the reality of you really are just human. I think that in many places, not every place, but in many places, there's been this heightened need for a realization that we need some better data. We need more and different data, and that kind of surveying interest. I've at least seen sort of a heightened interest in that, kind of finding out what the people really felt about what was going on. And I hope that those things kind of stay. The fade, I hope that there's sort of a willingness to realize, given that we've seen such decline in the numbers and everything else, that maybe we don't need to think of court as the first responder for anything, right? Why does the court want to raise a child? Whether it's on the dependency side or the juvenile justice side, why does the state want to raise a child? So let's figure out better ways, because it's a lot cheaper probably to spend all that money in the community rather than take the child away and raise it, you know, as a child of the state. My wish.
Yeah, excellent points, Melissa. You speak to the isolation within which judges and court staff do their work, which is one of the collateral benefits that I've personally realized with all of these many collaborations, is it gets you out of that isolation, and that in and of itself is therapeutic. And I think the pandemic has kind of forced us into that kind of environment. So excellent.
It's all, you know what, the other thing that Zoom has done is enabled judges more easily to watch other judges perform their job, right? You could sit in and watch someone else's hearing on YouTube, you know, for the public hearings, or, you know, in the internal court, things that judges may not have been inclined to walk into another judge's courtroom. So you can see and maybe get everyone on the same page a little better than before.
Absolutely, another collateral benefit. Thanks. So next up on that question is Charles, and then Judge Mendelson. Charles.
Thank you so much. I'm going to actually be really quick. I'm really just going to second everything that my colleagues said. One of the other things I just want to add to is this idea of scheduling. And really just kind of coming with a hybrid approach, right? Like, so maybe some people do have issues with access to those technologies and internet and those things, giving them the opportunity to maybe come in person as we begin to open back up in New York State, and just saying, okay, maybe, there are some other options for this, as well as one of the things I hope that is fading and that I hope stays kind of in that background and begins to fade away is this idea of excuses, right? It's been mentioned a couple of different times. Oh, we can't do this because it moves so slow. As Melissa mentioned, like we've seen this court system turn on a dime along with many other systems when this pandemic hit. So if it's possible that we don't have to wait 15 months to make something happen, I think we should keep that same mindset moving forward because we know that it can.
Excellent points. Thank you. Last but certainly not least, Judge Mendelson.
So hello again. What have we left behind? We've permanently left behind the assumption that courts were places where justice had to always happen in person. The virtual operations using the technology similar to what we're using right now to have this meeting with people all over the country and the world, perhaps, that's here to stay. And the idea that a physical appearance is necessary for every court action is no longer assumed. Virtual court operations, and I'm channeling the comments of everyone else, but it allows for many young people and their families to participate without disrupting their school schedule, their work schedule, their family life, getting a babysitter necessarily, things of that nature. However, I need to offer caution. I speak to many judges who have told me that for the juvenile justice involved young people, many of them, because of their facility with technology, may not take the court process as seriously if they can check into a remote Zoom or Microsoft Teams appearance. And some of the judges are indicating that if we have to prioritize in person, let's make it the situation where our young people can come into court. Perhaps their families can, if necessary, appear remotely. One of my many jobs is to oversee our state court system's access to justice program. And our goals are to, and we're very familiar with the digital divide that has been mentioned. And we're focusing on unrepresented court users and those who don't have the ability to join and use our technology. And we've come up with some creative solutions like having community court hubs and libraries and other spaces like faith houses of worship, where you don't have to necessarily come all the way to the court to participate in even the remote court appearances that we have. And we're working on increasing those opportunities and improving them for the community. Now, recognizing that COVID-19, people are looking for, and we are looking for the opportunity in crisis, but it really did create such hardship for so many, no one being untouched, but it did serve as a catalyst for positive change. I have never heard words like reimagine used so often, right? So since we are used to reimagining our justice system and reimagining how we do things, that's something that we should maintain. The idea that we don't have to remain stuck in practices that we've always engaged in, and we can be more creative and continue to reimagine. Practices that we engaged in that we need to keep. That whole idea when we thought that there was a public health crisis and it might be life or death for a child to confine them or make them very sick if we confine them in congregate care, that same sense of urgency and shared responsibility with all stakeholders wondering, does this young person need to be confined? That needs to remain. We shouldn't stop now that it's safer to be out and about. So that needs to remain. And what also needs to remain is our commitment to being bold and innovative and educating ourselves. I have listed as some of the things that I wanted us to maintain: our focus on trauma-informed courts, our recognition of the importance of procedural justice and compassion in justice. They can go hand in hand, and not forgetting what we learned from social scientists and others about adolescent brain development, and our responses should be community oriented.
Thank you, Judge Mendelson. Just a quick comment, and then we're going to move to what will seem like a speed round, so we have plenty of time for questions and answers. One of the challenges that occurs to me now is that we're going to need to continue to persevere with these innovative thoughts. To follow up on what Judge Mendelson said, that the almost daily, sometimes multiple times a day scrutiny that we as court supervisors place upon the judges we supervise to rethink their detention decisions. And we need to continuously not interfere with their decisions, but remind them that there are factors that they need to be thinking about. And that will become challenging, even more so, as we emerge from the pandemic. And also, as I think you've alluded to a couple of times, the environment in many of our communities with the uptick in violent crime among juveniles. We can't let that deter the thought process that we're engaged in now to be innovative. We can't, retrench or retract or go back to our comfortable spaces as we have many times in the past when these challenges surface. So thank you for your comments. So this is going to be a speed round, and I apologize for that. We have 3 questions. These are more individually focused questions. The first one is to Charles and Judge Mendelson. And I would ask that you take maybe a minute or 2 each to respond to this. So this question is, the overall focus of this day and this format, and what we're talking about is how do we collectively create a more just, more restorative, more equitable process for youth, their families, and communities. So from where each of the 2 of you are in your day jobs, in your lives, and your vantage points, what are the foundations of this work today, and what do you see continue to be the foundation of that work moving on into the future? Charles, you're first.
Definitely. I think one of the most important things to look at is this idea of really just keeping our young people out of the juvenile justice court system in the first place, right? And one of the things that we're working on right now in New York State and our organization as well is raising the lower age of raise the age, because right now in New York State, we prosecute and arrest young people as young as 7 years old, right? And it's like, at 7 years old, what do you actually know that you're doing? Your prefrontal cortex isn't even formed until you're 25. You're almost 20 years away from even being able to make conscious decisions. And yet we're putting them through the justice system, right? And so I think that's one of the biggest things that we need to look at is understanding, like, hey, we need to really keep them out of here in the first place. That's how we fix it. These young people are screaming, help me, not handcuff me. They're screaming, I need help. And I'm saying it in the only language I know how to speak because I'm 7 years old. I'm screaming it in my behavior because I don't know how to say what it is that I'm actually looking to say. So I think that's one of the most important things more than anything is just keeping them out of the system in the first place and getting them the help that they need rather than giving them these long-term consequences for momentary actions that they really didn't even understand that they were making in the first place.
Excellent, Charles. Thank you. Judge Mendelson.
So here is my opportunity to very briefly discuss the Equal Justice in Courts Initiative in 30 seconds or less. And I'm glad that our Chief Judge DiFiore mentioned it in her keynote address, because this Equal Justice Initiative talks to us throughout our entire court system. And I have been privileged to be asked to lead the day-to-day implementation for the state court system, our reckoning with racial justice in all of our courts. But I've been doing this reckoning for many years in our juvenile and child welfare spaces. We have to combat our racial bias and discrimination at all levels of the court system. And the work is twofold: how we are treated as court employees and judges within our system, and how we engage with and treat the public we are called upon to serve. So I think that's foundational to our being, to the immediate and long term in terms of how we're addressing juvenile justice system involved youth.
Thank you, Judge Mendelson. And for those of you that are wondering how Judge Mendelson does what she does in the course of a day, we're all wondering that. We're just darn thankful we have her. But what a tremendous inspiration in all of these initiatives, particularly the one you just referenced. So important to all of our work. And it needs to be thought about as a foundational principle in everything we do, but in particular, in most urgency, I think in the area of youth and families. So thank you, Judge Mendelson. Next question is for Professor Acker, and you're not allowed to say that you're not an expert in these areas, Jim. We're not taking that excuse anymore. So Jim, this is your chance to tell us in a couple of minutes, how should we use this moment to shift the priorities of the youth justice system? And what potential do you think those shifts have today as perhaps compared to maybe 3 years ago?
Well, it's a big question. Why do we do juvenile justice, and how do we do juvenile justice in 2 minutes or less? I expect that most people would agree that within the context of juvenile justice, our primary concern is for young people, trying to respond to those who engage in unlawful behavior in constructive ways, doing what we can to avoid having children get into these difficulties in the first place. And we also want to benefit society. One of the remarks I think Linnea made earlier was with respect to public safety. And while society certainly has an interest in the development of youth, it also has an interest in public safety and holding accountable those who do violate the law. Society also has an interest in the effective and efficient use of resources. So how do we prioritize these ambitions of helping youth, advancing social interests and effective use of resources? I think I would start with a process that relies on a couple of metaphors. Some have asked, what would I want if my child were immersed in the juvenile justice system? And I think that question should be taken from two perspectives. One, my child as a potential offender, but with respect to the public safety issue, also my child as a potential victim of offending, maybe very serious victimization. And how do we balance these interests? The other metaphor that I would use relies on John Rawls, the political philosopher's veil of ignorance, where you ask people to construct an optimal social policy, not knowing what side of the line you're going to fall on when the veil is lifted. So I don't know if my child will be a prospective offender, a prospective victim, or neither of the above. I don't know what the color of my skin is. I don't know a lot of things, but I'm going to construct these policies so that it's as fair as possible to all concerned. Now, we can't do this veil of ignorance literally, but what we can do is convene multiple stakeholders who have different perspectives, different insights, different interests, people from the community, victims, families, educators, court personnel. I think a very important set of participants are the police and prosecutors. To get them involved in these discussions, there's not only a potential outcome that can come from discussions of this nature, but the process is critically important. And when you get folks seated around the table talking meaningfully with one another, I think that breeds a very potential for positive change. And then hearkening back to what Charles suggested at the outset of this, we fashioned a plan in an organized, strategic way, and then we don't sit on it. We do something. We act, and I think that's a call for all of us to ask ourselves, what are we going to do after this webinar? It's been very constructive, it's been very informative, but there is a mandate to then take action. If I were to prioritize my own system, I'd focus on public safety as the principal concern of juvenile justice. I'd really keep in the forefront the disparities that we see with respect to race and ethnicity. I'd want restorative justice principles to remain very, very vibrant. And I would think seriously about how we're using our resources. I think it was Melissa who suggested that there are ways to make investments of resources that are more and less effective. And if we can get in front of some of these problems and not just be responsive, I think we'll go a long way to advancing our causes.
Jim, thank you. I'm happy that we're recording this meeting because I think you just gave us a blueprint for an excellent project moving forward that we could create pilot programs across the state and really put this in place to answer Charles's challenge at the beginning of the call. So we have 2 more speed round questions before we get to your questions. The next one is for Linnea. Linnea, speaking of action items and stuff that's really happening out there, tell us in a couple of minutes, and I'm sorry to cut you short, about the Washington Recovery Task Force's work that's focused on juvenile courts.
Thank you so much for this opportunity. So the COVID-19 Court Recovery Task Force is made up of all different court levels folks and then many committees. And so we have people who are on the task force who support voting members and inform decisions in those subcommittees as well. And so I chair the Child Welfare Committee, and then I co-chair the Juvenile Civil, Juvenile Criminal Subcommittee. And so in the Criminal Civil Subcommittee, we're preparing 2 recommendations for law changes. One, to increase the time that youth and families have access to diversion process programs and services. And then the second is kind of an interesting one. Had we never been looking at virtual or any of these processes, we probably wouldn't have looked at this kind of obscure law that hasn't been revisited since 1977. And there's a law on the Washington State books that requires fingerprinting, wet fingerprints, at the time of order of disposition, and then also in the adult world, judgment and sentence orders. And one of the things that we've really looked at and examined is that was the #1 thing that blocked young people from being able to have an access point of a virtual resolution of their case if they're facing felony charges. And because they had to come in to get fingerprinted. Now, these fingerprints that are affixed to the orders don't go anywhere. They're not entered into any database. It's just a practice that doesn't seem to be tethered to anything practical or really useful. So we are recommending that be stricken from the law books, and we're challenging the adult system to do the same. And then in our Child Welfare Committee, we're recommending changes to court rules to allow for permanent virtual options and in these types of dependency proceedings, as well as virtual witness testimony. The other thing that when we were looking at that court rule, it requires that every judge have the witness stand to administer the oath. And we also thought that was very old, archaic practice. Probably many judges aren't even utilizing that, nor would it be appropriate to require any person to ensure that they stand. So we're also recommending that change. And then, of course, our the work that we're doing with behavioral health options by increasing more telehealth across the state, especially to areas that have been underserved and tribal communities as well. And then we're also looking at our booking criteria on the books in 2005. Every warrantless arrest of a child or young person requires that the juvenile courts do what's called a detention risk assessment to assess if that youth really needs to meet booking criteria or can they be returned home and be summoned in. And so we're also looking at what those booking criteria is and looking at what changes have been made to even further reduce our detention populations.
Thank you, Linnea. Truly some action items that you're already embarked upon there. You've helped us answer Charles's question, and you're going to get us to more things that we can do here. So last in the speed round, Melissa, you have I was going to say the 40,000 foot view. You have a lot of perspective. You're involved in so many of these collaboratives across the country and maybe even beyond. I think you have more like the satellite altitude view, but could you just take maybe a minute or two and give us some common threads that you see in all of these conversations? Maybe give us 3 to 5 common threads.
Well, I mean, I think that certainly court folks are doing sort of what Linnea described, in that they're at least maybe not as formally with committees and all that, but, you know, looking and trying to figure out, hey, this has been different. What do we want to keep doing? And you know, are we just going to go back to the way things were? I would say from the data geeks that we deal with in court agencies and more correctional agencies, they're dealing with things like, how do we calculate recidivism rates with this 2020 year in the middle of it? Like, that doesn't, that's going to mess things up, and trying to figure that out. So I love that folks are really thinking about, you know, the data, and I would hope that most places, whether it's court, corrections, service agencies, would really think about, you know, do they have the data in hand to enable them to track after the pandemic, whatever changes they've put in place, is that still kind of an anchor? The pandemic happened to occur, though, during a number of years where there's been a big push for juvenile justice reform. You know, there's a lot of states made changes a few years ago, but several states were in the midst of juvenile justice reform councils, commissions, whatever, right in the middle of the pandemic. I happened to sit on the one in Maryland. And so I think there was like a real recognition of, wait, this is an opportunity. Let's not screw this up. You know, let's keep the numbers low and really, you know, be bold in our recommendations. What Maryland didn't do, that I would encourage every state to do, and maybe now is a good time while the numbers of kids in the system are low, to look at the purpose clause. Look in statute. Not every state has one, but most states do. What is the state's declared purpose for its juvenile justice system? And most states have language that's reflective of a philosophy and approach called balanced and restorative justice, which Jim touched on a little bit without maybe knowing it, but community protection, competency development, and accountability to victims and the community for the harm that is caused, being kind of the triangle that must stay in balance for things to work. I know as it was initially brought to the world and implemented in some states, there was also a kind of ring of the system should hold itself accountable to do a good job in all of these areas and keeping that balance, and to be transparent and tell the public what the heck is going on in the system. So we have seen a few states go beyond that, applying kind of a lens of what I would call the developmental approach. So acknowledging brain development, and you're not finished, you know, cooking till 25, and also the importance of data-informed decision-making, those kind of two real key components. And that right now is the balanced and restorative justice plus. There's like 5 states, I think, that have that language from, you know, reflective of those things in code, but most states at least have balance and restorative justice. I will say a lot of states threw it in there when it was popular, first introduced, and haven't looked at it since. Now's a good time to look at it and to really look at performance measures. How is your system doing against those ideals? Because balanced and restorative justice, if nothing else, was kind of a set of SMART goals. You know, can you measure it, and can you see, am I doing the thing that I set out to do? So I encourage folks that are in positions, whether it's on a state advisory group, if there is a task force of some kind or whatever, start with what your purpose is, because that should guide you. And if you're looking at what your purpose clause is now and are not satisfied with it, if it's from the 1940s, like maybe think of updating it, you know, and that should give you a, you know, kind of a pathway so that at least some years from now, you can have things that you will have been measuring to see how you're doing.
Excellent suggestions. And this has been a huge challenge, fitting so much into a smaller period of time. Thanks to everybody. We want to get to some of the audience questions now. And with the great help of some of the YJI staff, we're going to get to some of them, but not all of them. Apologies for that. Here's the first one, and I'm going to be bold here and suggest that we ask Judge Mendelson and Professor Acker to respond to this one. So this question is, how can we best facilitate the court university partnerships that a couple of us have spoken about here in a particular community? How can we make that happen, or how can we promote that? I would say there's no substitute to good old-fashioned putting people together. But Judge Mendelson's office oversees a lot of these collaborative projects and a lot of the logistics that are involved in that. So Judge Mendelson, take that question first, and then we'll go to Jim.
You just answered it. You know, working with court leaders, and our court leaders should be, you know, I'm willing to facilitate any of this in New York State. So reach out to me and we can have it coordinated. But you know, it can be locally, by court, by district. We can figure out how to do that. But we do need to, and we already have relationships with all of our, I believe we have 15 law schools, New York State based, and we will work with them and make sure everyone is involved and included and utilizes the specific clinical and other leadership that they have within the law schools and the courts.
Excellent. Jim, how do we reach out to the University at Albany and the expertise there and get you to partner with the court system? What do we do?
Well, in the old days, it'd be picking up a phone. Nowadays, it might be just an email, but I really think there's no reason in the world that these partnerships couldn't happen. It's just who's going to take the initiative. And while we're thinking about this, we can give a tip of our hat and a little encouragement in this area to the Youth Justice Institute, who would be a natural to facilitate and move forward with establishing, helping relationships of this sort go forward. Academics have a lot to gain in terms of devoting some of their time to public service, getting students immersed in real world research, interesting projects, cranking out dissertations. I would assume that the courts have a lot to gain in terms of, again, public service, capitalizing on the data and collaborating in a way. So I really think it's just a matter of who's going to pick up the phone first and get it going.
Excellent, Jim. All right, Melissa wanted to respond, and Linnea. So Melissa, you first.
Yeah, I just want to chime in, and I'm sure that Judge Mendelson is aware of this because she's not new to that game, but I would caution researchers, don't think you're going to go into a court and do your dissertation. It needs to benefit them. You know, it has to be that action research model of we are all working together on this, and these people in the court, even the data people and the not data people, they have expertise on how their system works. You really need them to understand what their data really mean. And by the way, it's dirty data. It's not clean and perfect data. So you have to really understand the data in order to use it. I will, not really as a joke, but Jeff Butts, who's the Research and Evaluation Center Director at John Jay, has a website, and he put this interesting little graphic, professional groups within the research community. So a bunch of circles. And, you know, there's some folks that are very scholarly, and that's all they know how to do is research to write a journal article. And that's not maybe going to help you. There's entrepreneurial people and there's governmental people, and, you know, they have sort of different motivations and stuff. So, you know, get help asking the right questions of the researchers.
Absolutely. Linnea.
Thank you so much. From a different perspective, I came into juvenile justice from academia, as a college student. My professor got a call from someone at one of our local facilities who said, we need help with young men who are incarcerated. They need access to education. And my professor famously said, I don't know what incarcerated youth need, I'll bring students and maybe they can find out. And so what we did is we used a participatory popular education approach, and we started an education program based on the needs of the young people who couldn't leave, and brought higher education into the facility. And so I'm not a researcher, I'm a person, the more you know, the more you owe. And now I'm gonna take Charles's famous words, what are you gonna do about it? Because that's the deal, like we have to get into the field. And so, yes, the phone works both ways. If that state worker hadn't called the university and said, I need some help, that partnership that has been happening now for 20 years would never have been formed. So it's really exciting opportunities out there.
Excellent. Linnea, the next question is for you. So keep your mute button off. What ideas do you have about how we could ensure the unique needs of rural youth are identified and centered and kept at the forefront during these times?
I really appreciate that question. Honestly, I think the needs of rural youth are similar to the needs of urban youth. Youth need connection. They need one connected adult. They need opportunities to grow and learn and to make mistakes, and to have someone care about them enough to say no and put those boundaries up. And I think that's what our system can do. And so any opportunities that we can think of youth as youth, and then recognizing that there's unique challenges to geography, and how do we impact those geographic challenges? Not so much the youth challenges, because I think kids are kids and each individual is going to be different, but I don't know that rural kids are so uniquely different than urban kids.
Thank you. Excellent point. And we have to end the question and answer period there. I'm very, very sorry for that. I don't know about the rest of you, but I'm feeling this this insatiable urge to be in a room with all of you and talk forever about these things and come up with ideas, and to get to Charles' question, what are we going to do about it? We really need to keep that at the forefront. But I just want to thank all of you for your patience with these tight time frames, and for what I think it was a remarkable conversation, one of the best, if not the best, I've had the privilege of being a part of. So thank you, thank you, thank you. And Dr. Lopez's picture on my screen means that I'm at a hard stop, so my part of the program is over with. So thank you all so much, and I know I'll see you soon. Take care.
Thank you, Judge Doran, and thanks to all of you for an incredibly insightful discussion. I learned so much from each of you. Linnea, I'm adding San Juan County to my list of places to visit as soon as it's safe. A reminder to the audience, you can follow the link that should appear in chat magically now and help us answer the question that our Chief Judge posed. What can courts do to support community initiatives or reform? So keep your answers coming. Thanks again to each of you on the panel and to our wonderful moderator, Judge Doran. Thanks for recommitting all of us to continue to inspire, to be inspired, to collaborate and persevere. As a researcher by training, I'm taking away 3 big things from this discussion here, or a call to action, particularly to funders, to academics, and to our community at large. Number 1, it was wonderful to hear how much of today's discussion centered on data and research. To Judge Mendelson's point, or should I say to Dr. Judge Mendelson's point, that knowing our data is foundational and necessary, I would call on the funders who may be in the audience to help localities build the necessary infrastructure to collect and report on those data. We see a lot of effort on the federal and the state side, but it's really the people in the field, right, in the local government that are helping build those data sets. So invest in that, please. And to shift the focus not just to quantitative, but to Melissa's point, qualitative data as well, which, as Linnea highlighted, might help us understand how individuals are experiencing the system. Now, I think that the senior executive director of the School of Criminal Justice is in the virtual crowd. So I'm putting it out there for her and my colleagues at the School of Criminal Justice. From my perspective as a criminal justice scholar, just as the criminal legal system is seeking right now to be bold and to innovate, I feel that our discipline of criminal justice is finally ripe to rethink itself, to rethink its curricula, and to shake up its methodological approaches to real-world issues, guided by a racial justice compass, which I think can be so very much enriched, for example, by participatory action research. So I hope very much that our field, and I don't know, Melissa, where that would fall in Jeff Butt's 3 circles there, but something in that direction would be amazing to see. My second point here, along the same lines, Jim stressed this imminent potential for partnership between courts and academia, and Judge Doran reiterated that invitation. So I hope that the academics in the audience will take advantage of this and help us all to continue to build this research-informed justice system. And yes, the YJI would be happy to facilitate those connections. So thank you for that plug. And number 3, as a reminder, Charles, you pointed out that we should be other-oriented and exercise cultural humility as we approach our work, be that work as researchers, as practitioners, as state and local reps, as officers of the court, or simply as kinder individuals, as someone in the audience shared in the chat. So your message resonated, and I hope you can see this word cloud from what everybody's taken away from today's forum, right front and center, big, bold, and in blue, cultural humility. So thank you again. Thanks also to each of you in the audience for your insightful questions, for joining us today. We'll be back tomorrow for more at 10 a.m. And we'll focus our shift to trauma and healing, which has permeated as a theme all of our discussions until now, but certainly will be front and center tomorrow. Our keynote address will be delivered by award-winning author Gary Young. And if you Google him, or perhaps now magically in chat, you will also see a link to a provocative piece that he published on The Guardian yesterday. So I urge you to check that out. If you haven't already registered, you can still do so. And the registration link also will be in the chat. Visit our website. Thank you very much, and I hope to see you tomorrow.